The next matter to come before us this morning is Bayview Loan Servicing LLC versus Karen Salem. Both sides will have 15 minutes to argue. If you're the appellant and wish to reserve up to 5 minutes for rebuttal, let me know what time you'd like to reserve, as I'm keeping the clock this morning. We've read the briefs and we are ready to proceed when you are.
Please the court. I'm Grace Doberdreck. I'm representing appellant Karen Salem, and I'd like to reserve 5 minutes for rebuttal. The trial court erred when it granted substitute plaintiff appellee Bayview Loan Servicing LLC's motion for summary judgment when the affidavit of Letitia Sanchez was not made upon personal knowledge. Specifically, if you look at paragraph 7 of her affidavit, she states that at the time of filing the complaint, plaintiff J.P. Morgan Chase Bank National Association was in possession of the original promissory note. This is an affidavit made by an employee of Bayview Loan Servicing. She specifically says in paragraph 2 of her affidavit that she reviewed records of Bayview Loan Servicing. She also never describes what her job duties are. But there's nothing to demonstrate that she had personal knowledge that J.P. Morgan Chase Bank, a separate entity, had possession of appellant Karen Salem's original note when this complaint was filed. And most importantly, there's no exhibit attached to her affidavit that would demonstrate that the original plaintiff had possession of the original note. Since this note is endorsed in blank in order to be the holded, they would have to establish that there was possession of the note. And in order to properly invoke the jurisdiction of the court, they would have to establish that the complaint was originally filed by an entity that had possession of the note.
Now, was that issue raised in response to the bank's motion for summary judgment?
And the appellant was pro se. She had filed what she had titled a motion to dismiss. She referred to Civil Rule 56. I think she was challenging
the affidavit in any way that would put that matter before
she
the
had
court.
argued that they didn't properly authenticate evidence through their affidavit. I think she had relied on Civil Rule 44, but she was challenging the documents that they had put forth, and then she had filed her own affidavit from somebody that she had to do a securitization report saying that this was in a Freddie Mac trust. So she was arguing that they weren't, she essentially was arguing they weren't the proper entity to be filing a foreclosure. So she was arguing that the note was in a trust, so she's saying that they didn't actually have possession. And the affidavit of Letitia Sanchez has this unsupportable statement in paragraph 7 that the original plaintiff, J.P. Morgan Chase, had possession of the note. Most recently in Deutsche Bank v. Dvorak, this court has said that there's no hearsay exception to simply say that somebody had possession without attaching an exhibit to demonstrate that you can't just make a statement in the affidavit. If you relied on a record under Civil Rule 56, in order for it to be considered, that document has to be attached to the affidavit. And there's no exhibit attached to this affidavit that would demonstrate that either Bayview or Chase had possession.
What is attached?
She has a copy of the note attached. Now, because she's from Bayview and they're the substitute plaintiff, she can't, through this affidavit, she can't demonstrate that J.P. Morgan Chase had possession without having access to Chase's servicing records or some. They could have filed an affidavit from a Chase employee saying we had possession of the note when we filed, but the appellee chose not to do that. And in this particular affidavit, they just merely attached a copy of the note. If you look at paragraph 10 of her affidavit, it's questionable whether she actually even knew what this note looked like, because she said the note's attached with any applicable endorsement.
So she doesn't say that, or they do not attach a certified copy or anything of that nature, and she doesn't say anything that would give us some information about how she obtained it and what her actions were before she swore out the affidavit.
That is correct, Your Honor. She never specifically states when Bayview Loan Servicing ever got possession of the note. She also never states under the standard in Wachovia Bank of Delaware versus Jackson in paragraph 49, for an affidavit in a foreclosure proceeding to be sufficient, the affidavit is supposed to say that they looked at the original and they compared it to the copy they're attaching their affidavit. She doesn't say that, and I think by also saying that she's attached the note with any applicable endorsements, it indicates a lack of personal knowledge of what this note actually looks like. And she doesn't say that she ever viewed this note, which I think is fatal. The fact that there's no exhibit demonstrating from Chase's servicing records that they ever had possession, I think is grounds for reversal under this court's decision in Bank of New York Mellon versus Walaba and Bank of America versus Loya. I don't think the standard that this court has set for affidavits was at all met by the affidavit filed by Letitia Sanchez. Additionally, one of the other arguments that we made in our brief is that in the judgment entry, the trial court judge seemed to resolve what could have been a material issue of fact in his entry. He noted that the signatures on the note endorsement from John Pelosi didn't match the signature on the assignment of mortgage, the corrective assignment of mortgage that's attached. So the judge noted that these signatures appeared different, but resolved what could have been a factual issue against appellant Karen Salem, and that by noting that not only did these signatures appear to not be made by the same person, but there's also an issue because the note endorsement was actually dated, which is rare. It appears to be dated the same day as the original note. It also looks like he could have signed as John L. Pelosi, but the signature is drastically different than on the corrective assignment of mortgage. The corrective assignment of mortgage is to J.P. Morgan Chase. So there could have been a factual issue of whether there was authority for the execution of the corrective assignment when the note was already purportedly endorsed on the day that they closed. And the judge had recognized that these signatures appear different. Since there could have been a factual issue, that should have been grounds for it to go to trial and not to just be resolved against the appellant within the judgment of foreclosure entry. And in BAC versus McFerrin, this court has made clear that the foreclosing plaintiff must have an interest in the note and the mortgage. They've also said that attaching a copy of a note endorsed in blank merely shows that the bank had possession, they had access to a copy of the note. It doesn't necessarily indicate possession of the note. And that's where there's an issue in this case, whether the original plaintiff had possession when they filed the complaint. Reserve the rest of my time for rebuttal.
Good morning, Your Honors. Mr. Oberda. May it please the Court. My name is Joanne Wu, and I'm counsel for App.No, Bayview Loan Servicing. This appeal stems from a judgment and decree of foreclosure that was granted in favor of Bayview Loan. It is Bayview's position that the trial court properly granted summary judgment in Bayview's favor. Ms. Salem's assignment of errors must be denied because Bayview was entitled to judgment as a matter of law. Ms. Salem's assignment of error must be denied because Bayview submitted a proper affidavit with evidence and exhibits to support the motion for summary judgment at trial court. There are two standards of review here. The first, with regards to the first assignment of error, it challenges the trial court's award of summary judgment to Bayview, which is reviewed under de novo review standard. The court must follow standards of Civil Rule 56 And the court will see that de novo review will reveal that there is no genuine issue of material fact that exists, and Bayview was entitled to judgment. The second error challenges the consideration of the evidence, which should be reviewed under an abuse of discretion standard. The facts will demonstrate that the trial court did not abuse its discretion, did not act unreasonable, unconscionable, or arbitrary. Your Honors, I would like to point out that Ms. Salem's assignment of error are procedurally barred. Firstly, Ms. Salem failed to file a timely answer to the complaint. And since Ms. Salem failed to file a timely answer to the complaint, those matters were deemed admitted. And even if this court finds that the answer was properly before the court, the answer, which was a one-page answer, admitted 3 important admissions. Firstly, Ms. Salem admitted default. She said it was due to unexpected disability which caused an unprecedented financial hardship. Secondly, Ms. Salem admitted J.P. Morgan Chase, hereinafter Chase, who is Bayview's predecessor, was the proper plaintiff when the complaint was filed, because she said she was working with the plaintiff and working on alternatives to foreclosure.
Well, let me stop you there. I read that in your brief, and I was not sure exactly what that connection is. So you have a person who has been making mortgage payments either to the bank or to the servicer, and gets notice that the bank is going to foreclose. The fact that he or she begins to work with an entity, whether it's the bank or the servicer, is that an admission that the entity that she's working with had the note at the time that the complaint was filed? I don't see that follows.
The answer specifically said that it was plaintiff, and furthermore, she failed to admit or deny any of the allegations as well. And we pursuant to Civil Rule 8D, when a defendant fails to deny the specific allegations of the complaint, it would be deemed admitted.
I guess I'm just trying to follow the reasoning that you're using, because she had worked with them, but you're saying that because she did not specifically deny the allegations in the complaint.
And also she refers to plaintiff as J.P. Morgan Chase. Furthermore, Your Honors, the assignment of errors that Ms. Salem raises are new issues that are raised for the first time of appeal. And it is well established that new issues or legal theories for the first time cannot be raised on appeal pursuant to Dolan v. Dolan, 11th District. Ms. Salem cannot challenge Bayview's affidavit. Failure to object to an affidavit in the trial court waives any right to object on appeal pursuant to Russo v. Acon Auto Transport, 8th District. Ms. Salem also waived any standing or real party and interest arguments. As I mentioned, Ms. Salem did not raise any defenses or any affirmative defenses, not even pursuant to Civil Rule 8C. Ms. Salem counters this point by arguing that standing can be raised at any time because it is jurisdictional, but she is mistaken. The Supreme Court of Ohio held that a court of common pleas that has subject matter jurisdiction over an action does not lose that jurisdiction merely because the party to that action lacks standing. And that's pursuant to Supreme Court case Bank of America versus Kuchta, decided October 8, 2014. Therefore, if standing is not raised, it is waived as a defense. And even if Ms. Salem's errors are merely harmless error incapable of review, and her appeal should be rejected. Pursuant to Civil Rule 61, the court must disregard any error or defect in the proceeding which does not affect the substantial rights of the parties. Even if Ms. Salem were to challenge standing to have JP Morgan Chase brought the complaint, she would be unsuccessful because the Ohio Supreme Court determined that the plaintiff need only establish an interest in the note or the mortgage when the complaint is filed, and that is pursuant to Schwartz-Wallow. Here, attached to JP Morgan Chase's complaint was a recorded assignment of mortgage that was executed and recorded to Chase prior to the filing of a foreclosure complaint.
How do we know that?
It was attached to the complaint, and the assignment shows that it was the date of execution and the date of recording was prior to the filing of the complaint.
How is it that the Ms. Sanchez, as an employee of Bayview, could aver with personal knowledge that J.P. Morgan had or did not have something at the time they filed the complaint?
Firstly, Your Honor, with regards to the requirements that are required for personal knowledge for a corporate affiant, it differs slightly. So with regards to a person, according to civil rule, evidence rule 901B10, a person that is required to lay the foundation of admissibility of documents is not required to have first-hand personal knowledge of the actual transaction. The authentication is that they have to be familiar with the operation of the business and the circumstances of preparation, maintenance, and retrieval of the record. And Ms. Salem avers in her affidavit that she was familiar with the operation and the business and the circumstances of the preparation, maintenance, and retrieval of the record.
Of the records for which entity?
Furthermore, she is able to rely on the records of JP Morgan Chase Bank. The entity submitting the business record need not have originated the document according to Great Seneca Financial, which is a 10th District case. Exhibits can be admitted as a business record of the entity even when that entity was not the maker of the records, pursuant to United States versus Trial, so long as they are received, maintained, and relied in the ordinary course of business. Because they were received, relied, and maintained upon in the ordinary course of business, Ms. Sanchez's Bayview affidavit could properly rely on those exhibits.
So after the assignment and the transfer, she can allege that from the beginning, the documents were properly handled, even though she has no personal knowledge of the previous corporate business practices or procedures.
That is correct. And Your Honor, public policy favors that because especially with regards to commercial paper and the selling and transferring of notes.
And that's in the UCC.
Yes, it prohibits previous entities from testifying for decades and decades to come in cases if that happens. But yes,
but also,
so long.
Have to tie that together with Civil Rule 56 and the requirement that the court be able to review what was relied upon. And so what was in the record, did the affiant attach to her affidavit those records upon which she relied to create the foundation for her ability to testify?
Yes, Your Honor. Ms. Salem did authenticate those supporting documents. Corporations and affiants are entitled to introduce business records to establish their case. Evidence Rule 803 excludes business records from the hearsay rule as long as the business records are authenticated, and the standard for authentication of those elements in which Ms. Sanchez averred to is Evidence Rule 803-6 and the three-pronged test of Great Seneca Financial, and that test is this. and all these Ms. Sanchez did avert to. First, the record must be one that is made in the regularly conducted course of business. Second, the contents of the record must have been made or entered by a person with knowledge of the recorded event. Finally, the event must have been recorded at or near the time of the occurrence. Here, Ms. Sanchez averts to those elements.
But did she attach the records to her affidavit?
She did, yes.
Okay, that's what I
Yes,
did.
the note, the mortgage, and all of the mortgage loan history documents, as well as all the assignment mortgage, they were all attached to her affidavit, 74 pages worth.
And another question, when you talk about the 3 sub-elements of 8036, can she simply aver the conclusions, or must she support her averment that it was kept in the regular course of the predecessor's business? Must she support that with some fact that would indicate how she was able to make that conclusion?
The standard is that she, pursuant to Greenwald Rehabilitation versus that Thatcher Six Sister case, that it's the familiar with the operation of the business and circumstances of the preparation, maintenance, and retrieval of the record, so long as it's within the ordinary course of business. So as long as Ms. Sanchez avers that that document has been kept within the ordinary course of business,
But that doesn't support that it was kept in the ordinary course of business before the assignment.
with regards to whether or not J.P. Morgan, the predecessor would be
Right.
J.P. Morgan Chase, and their possession of the note. J.P. Morgan Chase already established when they filed the complaint that they were the proper holder of the note. What happened was the loan, in the case, the loan was then assigned to Bayview Loan, and that's how Bayview Loan became the substitute plaintiff. Bayview averred that it received possession from J.P. Morgan Chase. Even if this court were to determine that certain averments of the Bayview affidavit were inadmissible, the fact would only preclude admissibility of that particular statement, not the whole affidavit as a whole, pursuant to LaSalle Bank versus Michael Street. But most importantly, the averments and the exhibits independently still evidence Ms. Salem's default and Bayview's right to judgment. Remember that Ms. Salem's answer admitted the allegations against her, which admission formed a source of independent evidence, and Bayview was entitled to judgment. Secondly, the affidavit's exhibits were self-authenticating records because they are commercial paper. The note and mortgage are commercial paper, and pursuant to Evidence Rule 9029, extrinsic evidence of authenticity as condition precedent to admissibility is not required with respect to commercial paper. And, Your Honor, I would like to point out that the 9th District Court case of Charter One Mortgage Corporation versus Caselica is on points with the facts of this case and favors the trial court's reliance on Bayview's affidavit. In Caselica, the bank obtained summary judgment and the borrower appealed. This court affirmed the award of summary judgment, stating that the affidavits complied with Civil Rule 56E, and that both stated that they were made upon personal knowledge.
And counsel, you have reached the end of your 15-minute time.
In this case, because Bayview was a substitute plaintiff, they had a dual burden. When they moved for summary judgment, they had to establish not only that Bayview currently had possession of the original note, but that the original plaintiff had possession of the original note at the time the complaint was filed. And that's what they failed to prove. In order to qualify for the business records exception, they need to not only authenticate the records, but they need to attach them to the affidavit if they want that considered under Civil Rule 56. Paragraph 7 of Letitia Sanchez's affidavit states that at the time of filing the complaint that JP Morgan Chase had possession. But there is no exception to the hearsay rule for that statement. She hasn't attached any records of Chase's, and her affidavit never says that she relied on any records of Chase's. So where is that statement coming from? What is the basis for it? She specifically says that she reviewed Bayview's records in paragraph 2, and in paragraph 3 that these records are compiled as part of Bayview's business activity. But she doesn't even refer to ever communicating with anybody at Chase, looking at anything of Chase's, doesn't even say when Bayview got possession of the note, and doesn't specifically say that she ever saw the original note. But most fatally for her, she didn't attach anything to demonstrate that Chase had possession of the original note when she filed. And so paragraph 7 is completely unsupported. In New York Mellon versus Vilava, you had a similar situation where there's the allegation that the plaintiff had possession, but there was nothing attached to the affidavit that would demonstrate that the bank actually had possession. Similarly, in Deutsche Bank versus Dvorak, no exhibit to demonstrate that there was possession of the note. Simply attaching the note doesn't demonstrate when possession occurred, even if they're saying that this is a note. Arguably, because in paragraph 10 she says the note with any applicable endorsements, similar to in Bank of New York Mellon versus Mahalka, where the affiant simply alleged that they were the holder of the note, this court reasoned that that indicated a lack of personal knowledge. Saying that the note attached with any applicable endorsements indicates a lack of personal knowledge. It indicates that she doesn't know what the note looks like at the time she's executing the affidavit, and certainly not when JP Morgan Chase filed the complaint. No reference whatsoever to JP Morgan Chase. For purposes of Civil Rule 56, there's no document attached to her affidavit. This affidavit's deficient under Civil Rule 56 because any record that's been reviewed is supposed to be attached and authenticated. And so if she's going to say that JP Morgan Chase had possession, she would need to, in order to support the motion for summary judgment, actually attach something that would indicate there was possession. And there are multiple ways the appellee could have done that, but they chose not to do that in this case, and that's grounds for reversal.
Is the Supreme Court's ruling in Wichita fatal based on what was not denied at the pleading stage?
I think Kupta actually helps appellant Karen Salem because Swartzwald, like Karen Salem's case, was a direct appeal of a summary judgment case. And Swartzwald held that standing is jurisdictional. In Kupta, that's also reaffirmed that standing is jurisdictional. In the Kupta case, it was a motion to vacate, so it was a different situation. But in Kupta, they did say that, although they said that standing doesn't go to subject matter jurisdiction, they did still say that standing is jurisdictional. And by not being able to demonstrate that they had possession of the note and that they had a right to enforce the mortgage when the complaint was filed, there would be no standing. They wouldn't properly invoke the court's jurisdiction under this court's reasoning in BAC versus McFerrin. The issue of whether you need the note or the mortgage, or the note and the mortgage is specifically before the Supreme Court now in the case with the appellant Sherry Lewis, the certified conflict case. But this court's decision and reasoning in specifically BAC versus McFerrin does say right now the law is in the 9th District that they need to have the note and the mortgage. And in this case, Bayview didn't demonstrate that the original plaintiff had possession of the original note at the time the complaint was filed. And that's fatal to appellee's motion for summary judgment. And it's grounds for reversal under this court's reasoning in Deutsche Bank versus Reynolds, Bank of America versus Loya, Bank of New York Mellon versus Malaba, Deutsche Bank versus Dvorak, and Bank of New York versus Mahalka. The affiant also never states what her job duties are, explains how they would give her knowledge about appellant Karen Salem's note and mortgage. And that has been grounds for reversal in other cases in this district, as the affidavit being deficient.
You have about 12 seconds left, so if you,
Unless there's any questions, appellate Karen Salem would respectfully request that you reverse the judgment of foreclosure.
thank you both for your presentations this morning. Court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court website.